Good morning. I am Dr. Harpreet Kaur, Professor of Law at National Law University, Delhi. Today I will be dealing with the module on insider trading offence and prohibition of fraudulent and unfair trading regulations in the securities market and their implications. We know that recently we have seen that the offence of insider trading is increasing tremendously as the growth of the securities market is also going on very fast pace for the last 1 decade. SEBI had formulated 1992 regulations which prohibit the offence of insider trading. So in this module, we will deal with the insider trading regulations as well as regulations which are prohibiting fraudulent and unfair trade practices in the securities market, which are regulations of 2003, as well as the special provision of section 195 of the Companies Act 2013. Now we know that 1992 regulations are in place since 1992 only, but there has been increase in the number of offences of insider trading. So it was thought by SEBI that there should be some amendment made in the insider trading regulations. For this purpose, a committee was constituted by SEBI under the chairmanship of N.K. Sodhi, and which had given its recommendations. And while I was writing this module, the recommendations of N.K. Sodhi committee and certain other changes were proposed, and on the basis of this we had replaced the 1992 regulations with the 2015 regulations. So in this module I will be making a comparison between the 1992 regulations and 2015 regulations, and will try to make you understand that what has been the need for making such replacement and whether it will be the new regulations will be able to regulate the offence of insider trading more vigorously or not. So this is the introduction about the module. Now let us understand what is the learning objective of this module. So there are 4 learning objectives. First, we need to understand what is the insider trading and who are potential offenders for insider trading. We need to understand how insider trading is regulated in India, and also we need to understand why there was a need for the replacement of the insider trading 1992 regulations with 2015 regulations, and also we will see what are fraudulent and unfair trade practices in the securities market in India and how they are regulated. So let us first of all understand what is the prohibition contained in these 2 regulations 1992 and 2015 about the insider trading. So 1992 regulations under regulation 3 says that the insider trading is prohibited, and it says that no insider shall deal in listed securities of any company when he is in possession of any unpublished price sensitive information either on his own behalf or on behalf of any other person. So this is about the prohibition on dealing in securities when the person is having possession of unpublished price sensitive information. The second part of the prohibition says that such person should not communicate, counsel or procure any such information, whether directly or indirectly, to any person while in possession of such information that other person cannot also deal in the securities. So it is not only the prohibition in dealing by one person or any dealing on his own behalf, but the communication of this information to some other person who is also prohibited from dealing in the when he is having possession of unpublished price sensitive information. Now this prohibition is not applicable when the communication is required in the case of ordinary course of business of the company or profession or employment or under any law. Now let us look at prohibition under 2015 regulations. It says that communication or procurement of unpublished price sensitive information is prohibited, and it says that no insider shall communicate, provide or allow access to any unpublished price sensitive information to any person including other insiders of the company, and no person shall procure from any insider any unpublished price sensitive information or cause the communication by any insider of any unpublished price sensitive information which is related to a company or related to the securities which are listed or proposed to be listed. The exception says that such procurement or communication is allowed when it is in furtherance of legitimate purposes, performance of duties and discharge of legal obligations. So we say that the prohibition, the scope of this prohibition has been increased, and the exception which is given in 1992 regulations about the ordinary course of business, profession or employment or under in any law has been changed now with the legitimate purposes, performance of duties or discharge of legal obligations. Now, who is an insider? So, under 1992 regulations, insider is any person who is reasonably expected to have access to unpublished price sensitive information regarding the securities of a company because he is or he was connected with the company, or he may also be deemed to have been connected with the company. So, we are talking about a person who is insider and who is also deemed to be connected with the person, or who has received or has access to such unpublished price information. So, this is the definition of insider under 1992 regulations. Let us now look at the definition under 2015 regulations. Under 2015 regulations, insider means any person who is a connected person or who is in possession of or having access to unpublished price sensitive information. So, you see that the definition has been simplified, but the scope has been widened in this definition. Let us now look at who are connected persons under 1992 regulations. So, connected person means, or it meant under 1990 regulations, as a director or of a company or a person who is deemed to be a director of that company, or who occupies the position as an officer or employee of the company, or holds a position involving a professional or business relationship between himself or and that of the company, or who may reasonably be expected to have an access to unpublished price sensitive information. Now, over here the connected person meant that this person will be in connection with the company in only for 6 months prior to an act of insider trading. So, the person will be connected person only if he was in the category of connected persons 6 months prior to the dealing of the insider trading. Now, under 2015 regulations, the connected person means any person during the 6 months prior to the concerned act, if he has a relationship or he is connected with the company, has been associated with the company either directly or indirectly in any capacity, which may include his frequent communication with the officers of the company, any contractual or fiduciary or employment relationship with the company, or he being a director, officer or employee of the company. Now, the second part of the connected person says, definition says that he may be a connected person if he holds any position including a professional or business relationship between himself and the company, whether it is temporary or permanent, and that allows such person directly or indirectly access to unpublished price sensitive information, or he is reasonably expected to have such access to unpublished price sensitive information. So, again we see that the scope of the definition of connected person has been enlarged over here. Now, there is another category of deemed connected person under the 2015 regulations. Now, over here the following persons will be deemed connected persons. First, an immediate relative of the connected person, as we have discussed just now. Then any holding company or associate company or subsidiary company, any official of a stock exchange or a clearing house or a corporation, any intermediary as is specified in section 12 of the SEBI Act, as well as any investment company, trustee company, asset management company, or any employee or director of such companies. The next category of deemed persons include a banker of the company, a member of the board of trustees of a mutual fund, a member of the board of directors or an employee of a public financial institution, and any official or employee of a self-regulatory organization which is recognized by SEBI board, and a concern or firm, trust or Hindu undivided family, company or association of persons wherein a director of a company or his immediate relative or banker of the company has more than 10% of the holding or the interest in another company. So, these are the categories of deemed connected persons. Now, we also need to understand what is price sensitive information. So, under 1992 regulations, price sensitive information means any information which is directly or indirectly related to a company and which, if published, is likely to materially affect the prices of the securities of a company, and certain informations are deemed to be price sensitive information. For example, periodical financial results of the company, intended declaration of dividends of the company, whether interim or final dividend, issue of securities or buyback of securities, any major expansion plans of the company or execution of new projects of the company, amalgamations, mergers or acquisitions or takeovers of the company, disposal of the whole or substantial undertaking of or the part of the undertaking of the company, any other significant changes in the policies or plans or operations of the company. All these were deemed to be price sensitive informations under 1992 regulations. Let's have a look at unpublished price sensitive information under 2015 regulations. Now over here, before understanding this price sensitive information, we need to understand what is generally available information, because on the basis of generally available information, the definition of unpublished price sensitive information or UPSI has been given by the 2015 regulation. Now generally available information means information that is accessible to public on a non-discriminatory basis. Now on the basis of this, let us now understand what is unpublished price sensitive information, and it means any information again relating to a company or to its securities, whether directly or indirectly, and the information which is not generally available, which upon becoming generally available is likely to materially affect the price of the securities, and it shall ordinarily include the following but is not limited. So there are also deemed unpublished price sensitive informations in this case also, which are financial results, dividends, change in the capital structure of the company, mergers, demergers, acquisitions, amalgamations, listings, delistings, disposals, expansion of the business, and such other transactions, changes in the key managerial personnel, and material events in accordance with the listing agreement. So you see that here we have two more categories where we are talking about changes in the material in the managerial personnel, as well as changes in the material events in accordance with the listing agreement. So over here we have expanded again the scope of deemed unpublished price sensitive information over 1992 regulations. Now both the regulations, they had instructed that there should be code of internal procedure and conduct. In 1992 regulations, the company had to make a code of internal procedures and conduct which should be followed by the company and its employees while dealing with the unpublished price sensitive informations. Now 2015 regulations talk about two types of codes. First is the code of procedure and practice, which says that a board of directors of a listed company has to formulate and publish a code of procedures and practices for fair disclosure of unpublished price sensitive information, and this procedure has to be, these procedures have to be followed by persons who are engaged in or who are having access to unpublished price sensitive information. The second point says that board of directors of any company or any intermediary or any person who is connected during the operations of the company, business operations of the company, has an access to the unpublished price sensitive information. He has to formulate and also publish code of conduct for the regulation, monitoring, as well as reporting of the trading of its employees, as well as have a look into the compliance of the provisions. And for this purposes, they are also mandated to appoint a compliance officer. So this provision has been stringent not only for the company but also for the intermediaries and other persons who are associated with the company. Now there were certain disclosures which were required under 1992 regulations. So under 1992 regulations, three types of disclosures were required by any person who was holding more than 5% shares or voting rights. Then the second category of directors and officers of the listed company, and the third category of disclosures were required by any person who is part of the promoter group or he is a promoter himself. So let us look at the first category of disclosures. So any person who is holding more than 5% shares or the voting rights in any listed company, he has to disclose to the company within 2 days of acquiring these voting rights or the shares, and he is also under the responsibility of continual disclosure if there has been any change from his last reported shareholding or voting rights, and if this change exceeds more than 2%, then whether it is increasing its shareholding or voting rights or decreasing its shareholding or voting rights, he has to continually disclose this to the company. Now, any director or officer of a company also is required to disclose the number of the shares or his voting rights which he has in the company, and also the positions which he has taken by himself or by his dependents within 2 days or of becoming such director or officer of the company. And he is also required to disclose any change in his position where the change exceeds 5 lakh rupees in value, or 25,000 shares, or 1% of the total shareholding of the of him in the company, whichever is lower. So when we are talking about shareholding, we are also referring to the voting rights. Now, any person or part of the person who is part of the promoter group, again he has to disclose the number of shares held by him and the positions and the voting rights or the shareholding which he has held in the company, and also if there is any change in the voting rights or the shareholding of the company or the change in the position in the company, then he has to continually disclose that information to the company. Now, let us look at the disclosures which are required to be made under 2015 regulations. So, the first point says that concerned persons, they have to disclose not only their own trading but also the trading which are done by his immediate relatives or any other person for whom the trading decision is taken by him. So, this is more stringent on the concerned person who is under this responsibility of disclosure. Two types of disclosures again have to be followed: initial disclosure as well as continuous disclosure. So, under initial disclosure, this has to be made by certain persons. And who are these certain persons? Every existing promoter, key managerial person and director of every listing company is required to disclose his shareholding to the company within 30 days of enforcement of these regulations or 7 days of such appointment. And he has to continuously disclose this to the company if there has been change in the number of securities held by him, whether he has acquired securities or whether he has disposed of securities, and if he has to continually disclose this information if the value of such transaction exceeds 10 lakh rupees. Now, let us see what is section 195 of Companies Act says. It prohibits insider trading of securities in the companies, and it says that no person, including any director or key managerial personnel of a company, shall enter into insider trading. And this prohibition obviously does not apply to communication which is required in the ordinary course of business, profession or employment. Now, the insider trading has been defined as an act of subscribing, buying or selling, or agreeing to subscribe, buy or sell or deal in any securities, which may be by directors, key managerial personnel or any other person of the company, either as a principal or an agent. So, that means even if you are an agent and involved into insider trading dealings, you will be liable to punished under this section. And obviously, this will be applicable only if the concerned director or managerial personnel or other person is having or the other officer of the company is having access to non-public price sensitive information regarding securities of the company. And the second point says that any act of counseling about or procuring or communicating directly or indirectly any non-public price sensitive information to any person will also be prohibited under this particular section. And price sensitive information over here means any information whether it is directly or indirectly related to a company, and which if published is likely to materially affect the price of securities of a company. Now, let us come to the SEBI prohibition of fraudulent and unfair trade practices relating to securities markets regulation 2003. And these regulations they have a restriction or the prohibition on buying, selling or otherwise dealing in the securities of the company, and it says that a person shall not directly or indirectly deal in securities in a fraudulent manner or use or employ in connection with the issue, purchase or sale of any securities or stock on any stock exchange, any manipulative or deceptive device or contrivance in contravention of these regulations, employ any device or scheme or artifice to defraud in connection with dealing or issue of securities which are listed or proposed to be listed, or engage in any act, practice or course of business which operates as or would operate as a fraud or deceit upon any person in connection with the dealing or issue of securities which are listed or proposed to be listed in contravention of these regulations. Now over here we have to understand the definition of fraud, because the regulations have given the definition of fraud also. So the fraud over here means it is not a definition which says that fraud means, but it's an inclusive definition which says that fraud includes any act, expression or omission or concealment committed by a person or by any other person with his connivance or by his agent while dealing in securities in order to induce another person or his agent to deal in the securities of the company. And there are certain activities which are deemed to be fraudulent activities. First is a knowing misrepresentation of the truth or concealment of material fact in order that another person may act to his detriment, a suggestion as a fact which is not true by one who does not believe it to be true, an active concealment of a fact by a person having knowledge or belief of the fact, a promise made without any intention of performing it, a representation made in a reckless or careless manner whether it be true or false, any such act or omission which any other law declares to be a fraudulent activity, deceptive behavior by a person depriving another of informed consent or full participation, a false statement made without any reasonable ground for believing it to be true, then the act of an issuer of securities giving out misinformation that affects the market price of the securities, resulting in investor being effectively misled even though they did not rely on the statement itself or anything derived from it other than the market price. So these are the this is how the fraud and the fraudulent activities have been defined by the regulations 2003. So you can see that whatever information of definition of fraud has been included under the Contract Act of 1872 and under the law of torts which was defined in the case of Derry versus Peak. All such information or the variants of the fraudulent activities have been included under this definition of fraud under the 2003 regulations. Now let us look at the prohibition of manipulative and fraudulent and unfair trade practices under these regulations. So the regulation 4 says that no person should indulge in acts which create false or misleading appearance of trading in securities market, dealing in securities not intended to effect the transfer of beneficial ownership, but in order to act as a device to inflate or depress or manipulate the prices of the securities in the market, which obviously would lead to wrongful gain or avoidance of losses, and then advancing or agreeing to advance any money to any person, thereby inducing that person to offer to buy any securities in order to complete the minimum subscription requirement, paying or offering or agreeing to pay or offer directly or indirectly any person any money or money's worth for dealing in security with the object of inflating, depressing or maintaining or causing to fluctuate the prices of the securities in the market. Then any act or omission amounting to a manipulation of the prices of a security, then publishing or causing to publish or reporting or causing to report by a person dealing in securities any information which is not true and which he does not believe to be true prior to or in the course of the dealing of securities, then entering into transactions in securities without the intention of performing them or without the intention of changing the ownership of such securities, selling, dealing or pledging of stolen or counterfeit securities. There are certain prohibitions which are referring to the intermediaries also. So any intermediary promising a certain price in respect of a buying or selling of a security to a client, obviously in order to make some profit, any intermediary providing his clients with information relating to a security which cannot be verified by the clients before dealing in such securities, any advertisement that is misleading or contains information in distorted manner, any intermediary reporting trading transactions to his clients entered on their behalf on an inflated manner in order to increase his commission or the brokerage. Then any intermediary not disclosing to his client transactions which are entered into on his behalf before taking any option position. Then circular transactions are also prohibited. Then any any act which is encouraging the clients by an intermediary to deal in securities solely with the object of enhancing its brokerage or commission without information to the persons who are dealing in these securities or who want to invest their money in these securities, and any intermediary predating or otherwise falsifying records such as the contract notes. Last 3 points says that prohibition is also on planting false or misleading news which may induce a sale or purchase of any securities. Then it also prohibits mis-selling of units of a mutual fund scheme by making false or misleading statements. Then illegal mobilization of funds by sponsoring or causing to be sponsored or carrying on or causing to be carried on any collective investment scheme by any person. So you have seen that almost all type of activities or the dealings or of buying or selling or otherwise transacting in the securities market, everything has been which leads to the manipulation of the prices or inflation or depression of the prices or any kind of unfairness to the investors, or it is fraudulent to the investors. Every such kind of a deal has been prohibited under regulation 4 of 2003 regulations. Let us now discuss few cases which are related to the topics in hand. Let us deal with the case of Samir Arora versus SEBI. Samir Arora was the fund manager of a company which is known as ACMF, which is Alliance Capital Mutual Fund. Now this ACMF had 10% shareholding in DGL, which is a Digital Global Soft Limited. Now this DGL was proposing a merger with HPISO. So this knowledge of this merger was in the public domain, but there was another factor which was very important over here, that before this proposed merger between HPISO and DGL, there was a demerger which was proposed between HPISO and HP, which was a very important factor and which was not in the public domain. Now Samir Arora, he had a relationship with the with DGL company, Digital Global Soft Solutions Limited, and over here with this interaction, during the interactions he came to know of this demerger and he started trading on this information, and SEBI found him to be guilty of insider trading, and he was prevented for dealing in securities market for a period of 5 years. Another case is related to Reliance Industries. Now in this case there was an information which was given to SEBI that Reliance Industries has 10.05% share in L&T, and which it is proposing, which it is selling to Grasim Industries Limited. Now the information which was provided was that before selling this, immediately before sale of L&T share to Grasim Industries Limited, Reliance had increased their stake from 6.62% to 10.05%, and the rate of purchase of these shares, per share it was rupees 150 only, whereas when they sold these shares the price was around 306 rupees. So over here it was alleged that they had been involvement of Ambanis into it, and because they were the insiders to this company. Now over here we should also know that that Ambanis, they were the directors on board of L&T. So SEBI said that this information had come to them not in the position of insider, although Reliance RIL over here is falls under the category of connected person, but this information did not came to it in the while they are in the position of insider, while they are in the position of insiders in the company. So they were not found guilty of this offense of insider trading. So let us now discuss the case of Abba Sharma versus SEBI. Now in this case SEBI was investigating into the trading pattern of certain persons from December 2009 to March 2010, and we should understand that Abba Sharma had a trading account with Eureka Stock and Share Broking Services Limited, and her husband Jitendra was an equity dealer for Central Bank of India. And it was found by SEBI during the investigation that for initial 16 days, at the end of the trading day, the net quantity was 0, and for next 14 days the sell order of Abba Sharma was exactly equal to the buy order of Central Bank of India. Now over here, this was found to be a case of front running, and SEBI found them guilty of the front running, and they appealed to SAT, and SAT obviously had to look into this, because in an earlier case of Deepak Patel versus SEBI, SAT has said that in case of front running, where any person other than intermediary, if he enters into any trading on the basis of forthcoming transactions of another trader, then it will not be fall under the insider trading regulations. But SAT over here dismissed the appeal of Abba Sharma, and it was decided that they were engaged in the offense of front running, which so they were held guilty. So SAT over here overruled its own decision of Deepak Patel versus SEBI, and now the latest position is that any intermediary, any person other than intermediary, if he is involved into trading transactions on the basis of information of forthcoming transactions of any other trader, they will be held liable under the insider trading regulations. The next case is of Sadhna Nabera and Dilip Nabera. Now in this case, Dilip Nabera was a shareholder of Sun Infosys Limited, and he had 10,500 shares, and his wife Sadhna Nabera also had around 5,300 shares in Sun Infosys Limited, and besides that she had 50% shareholding of Adhunik Finance Limited, and she was the whole-time director of Adhunik Finance Limited, and Dilip Nabera was auditor of Sun Infosys Limited. Now at the time of joining as an auditor, he had disclosed that he had so much of shareholding in Sun Infosys Limited, but he did not disclose that his wife is also having 50% shareholding in Adhunik Finance Limited and is also a whole-time director of the Adhunik Finance Limited. Now there was a merger proposed, not exactly a merger. Now in this case, the problem arose when Sun Infosys wanted to acquire ZAP Infotech Limited. Now when this acquisition, this knowledge was not in the public domain, but it was known to Dilip Nabera. So there was a trading which was done by Adhunik Finance Limited. So in their defense, they said that they have not traded on their own account, but this was done by Adhunik Finance Limited, which is acting as a sub broker for its clients. So they were not indulged in any kind of insider trading activities, and the SEBI found them guilty, but SAT said that an auditor is not in a position to have any unpublished price sensitive information. So these are few cases which may have given you an hint that how the insider trading regulations, they are applicable, or how fraudulent and unfair trade practices regulations, they are applied by SEBI, as well as how they are decided by SAT. So in this module we have discussed about the concept of insider trading, both under the 1992 regulations and 2015 regulations. We have made the comparison. Over here I would also like to inform you that the new change which has been made by 2015 Act is that the persons who are key managerial persons or directors of the company, they can give their trading plan before any financial year, and on the basis of trading plan, whatever they give, they can continue with the trading. But over here there are certain cautions which have to be taken, because if they do not trade on behalf as they have given it in their trading platforms, they may incur some liabilities also over here. So in this module we have discussed about insider trading, as well as the concept of fraudulent and unfair trade practices, and how they are regulated by the by regulations of SEBI, which is market regulator for the securities market in India. Thank you very much.